What's up? What's up? What it do? Today it was brought to my attention. I got several questions about third-party cooperation, and I really feel like we'd have talked about this a whole lot of times dealing with this Demetrius Flannery, BMF, Dion Gatlin. Shout out to Cuffy. Shout out to St. Louis, free Cuffy. I think we'd have talked about this a lot of times. I mean, and that's cool because I'm covering content and I like to read law. I like to understand the law. So let me explain something to you. And this is not me taking a shot at nobody. People keep asking me about third party cooperation. I spoke on third party cooperation some time back. So the person came at me said, "Yo, I thought you said they do third party cooperation." People say that it's not done. Once again, I'm not talking to anybody specifically. I'm talking about the truth. They do third party cooperation in the Northern District of Georgia. I'm going to show you that. Also, I want to point out something else. I see a lot of people keep saying that what difference does it make if they was doing a third party cooperation in Georgia? Because Meech's case comes out of Michigan. This is all true. But I'm not going to beat a dead horse. I'm just going to explain this to y'all. Rayful Edmond, one of the biggest rats in U.S. history. Sadly, he's from Washington, D.C., so I follow this case. Rayful Edmond and his mother both got their federal sentences out of the District of Columbia. Rayful Edmond later got caught up in Pennsylvania. It was Pennsylvania. Rayful Edmond cooperated in Pennsylvania. Okay, follow me. And gave his mother the benefit of that cooperation because the government was not willing to give him a benefit for his cooperation. So they gave his mother a Rule 35. They gave his mother the benefit, and his mother went home. His mother never had a case out of Pennsylvania. Pennsylvania did not reduce her sentence. The judge in her case that came out of the District of Columbia reduced her sentence based on the cooperation of Rayful Edmond. So once again, sadly, we could use Rayful Edmond, his cooperation, as a lesson in cooperation. Once again, he cooperated in Pennsylvania. They gave his mother a benefit who was in prison serving time at the same time. Her benefit and her time cut came out of the District of Columbia. Let's go back to the scenario. Tammy is operating where? She's operating out of Atlanta, the Northern District of Georgia. Jack Harvey is working in the Northern District of Georgia as a DEA agent. Keith Cromer, DEA agent Keith Cromer, works out of where? The Northern District of Georgia. So let me give you the scenario. I know a lot of people say, you put your thoughts in it all the time, but that's the purpose of me giving you my thoughts. In a perfect scenario of a third-party cooperation pertaining to Demetrius and Tammy, Tammy would have cooperated, worked, got some big buzz, gave the benefit to Demetrius. If the DEA would have shoveled it to the district attorney, the U.S. attorney in Michigan, and they presented and they filed a Rule 35 motion on behalf of Demetrius, the judge in Michigan would have gave Demetrius that time cut. Now, there is no Rule 35 in Demetrius' jacket, as far as I see, and I done went over it several times. I ain't afraid to say that. There's no 5K1 in there. I'm not afraid to say that. I never said Demetrius was a rat, but I'm not backing away from what I did say. What I did say is that Tammy was an informant. At some point in time, Demetrius knew she was an informant. The big question is, when did he know was she an informant? That's the factual basis. Now, to go back into the schemes, because some of these guys think they smarter than everybody else. So if you go into the scheme of things, I believe that they schemed and they attempted to do this. And where I come from, you still not right. But let's get to the facts. What the facts are is that Cuffy ain't no Tammy from a can of paint. Suarez ain't no Tammy from a can of paint. Demetrius Flannery is the one who knew all of these people. And Demetrius Flannery introduced Tammy to Cuffy, introduced Tammy to Suarez. I'm only want to deal with Cuffy at this point. He introduced Tammy to Cuffy. Cuffy introduced Tammy. Demetrius introduced Cuffy to Tammy. Tammy introduced Cuffy to CS2. CS2 is the linchpin to what Cuffy got arrested for. So everybody want to separate Tammy from that. I'm only going to make one point. You cannot separate Tammy from Cuffy. You cannot separate Tammy from Cuffy's charge, the drug charge at least, because the affidavit, remember this, y'all, the affidavit that was submitted to get the Title III wiretap on Cuffy's phone came from information that was provided to DEA St. Louis by Tammy. Tammy was introduced to Cuffy by Demetrius. Now, for those who don't know, I just want to give you a quick understanding of what a Rule 35 is. Rule 35, right, is the Federal Rules of Criminal Procedure number 35, but we're only talking about B. Rule 35B, right? And I'm going to just read Rule 35B to you. So when you hear people say, oh, Demetrius don't got a Rule 35. He ain't got a Rule 35. They're talking about 35B. I will stamp, I don't see no Rule 35B in the docket. I will say that. All right. Rule 35B, I'm going to read it to you straight out of the law book. B is reducing a sentence for substantial assistance. Number one, in general, upon the government's motion made within 1 year of sentencing, the court may reduce a sentence if the defendant, after sentencing, provided substantial assistance in investigating or prosecuting another person. Number two, later motion. Upon the government's motion made more than 1 year after sentencing, the court may reduce a sentence if the defendant's substantial assistance involved A, information not known to the defendant until 1 year or more after sentencing, B, information provided by the defendant to the government within 1 year of sentencing, but which did not become useful to the government until more than 1 year after the sentencing, or C, information the usefulness of which cannot reasonably have been anticipated by the defendant until more than 1 year after sentencing, and which was promptly provided to the government after its usefulness was reasonably apparent to the defendant. They also have a 3 in here, which is evaluating substantial assistance. In evaluating whether the defendant has provided substantial assistance, that's information that really is going to get somebody nailed to the cross. The government may consider the defendant's pre-sentence assistance. And number 4, below statutory minimums. When acting under Rule 35B, the court may reduce the sentence to a level below the minimum sentence established by statute. That's all the provisions under Rule 35B, okay? Now, you know what a Rule 35 is. You know that Demetrius don't got the Rule 35, so that is out of the situation. Now, I'm going to read to you a case. And I'm only going to read to you the background of the case. Everybody not interested in reading a whole bunch of law, this case, that case, this case. But this case is a case out of the Northern District of Georgia. And it's a case that specifically identifies third-party cooperation, and it shows you that the judge reduced the person's sentence. All right, this is where I'm coming from right now. I'm coming from U.S. versus Hubbard, Hubbard, okay? Case number 09-12474, all right? This is an appeal from the United States District Court for the Northern District of Georgia. Northern District of Georgia. Remember, it's been a big old topic on the internet today about the Northern District of Georgia does not do third-party cooperations. I'm telling you that it's not true. I'm telling you I'm telling you that that is not true, and they do third-party cooperations all the time. All right, let's get straight into it. Dexter Hubbard, proceeding pro se, appeals the district court's ruling on the government's motion for a reduction in his sentence, pursuant to Federal Rule of Criminal Procedure 35B, based on Hubbard's substantial assistance to the government. Although the government asked for only 2-month reduction, a 2-month reduction, the district court reduced Hubbard's sentence by 24 months, from 294 months of imprisonment to 268 months of imprisonment. On appeal, Hubbard argues that the district court should have given him a greater sentence reduction based on his wife's third-party cooperation with the government. Hubbard also contends that the government violated his due process and equal protection rights by misleading him about the extent of his reduction and arguing against him receiving a significant reduction. So let me stop right there. Not only did this dude get a 24-month reduction off of 292 months, he got a significant reduction off of 292 months down to 268 months. And he still filed an appeal to say that that wasn't enough, and that the government, which they had to, I'm showing y'all, that even if his wife went out here and did this cooperating and he got this 24-month reduction, I'm showing y'all that in the process of setting up a third-party cooperation, the person who gets the benefit that's in prison knows what's going on. He even filed an appeal to show that, hey, the government gave me an impression that I was going to get a bigger reduction in this. My wife put her life on the line. She's not a criminal, and they gave me the benefit. And the government going to sit here and say, oh, only give him 2 months. And then argue against the judge giving him 24 months. Dexter Hubbard, look his case up, man. Let me read this next part to you. To the extent Hubbard seeks to challenge the extent of his reduction or the weight given by the district court to his wife's cooperation, we lack jurisdiction to review these claims. I'm going to stop there. Not only did he appeal to 24 months, he got the government only wanted to give him 2 months. Why the government would want to give him 2 months on a 292-month sentence? So the government, look how vicious the government is. They say, go help us out. You have your wife go undercover for us. You can go deep cover. We're going to give you 2 months. We're going to drop your sentence from 292 months to 290 months. Even the judge in the Northern District of Georgia said 2 months. No, I'm going to give him 24 months. They do third-party cooperations in the Northern District of Georgia. Go look up Dexter Hubbard, bro. I'm a real law librarian, bro. Like, I really looks at this stuff. I'm not going to tell you nothing wrong. Now, yeah, Keith Cromer is quoted in some of the cuffy paperwork as telling Tammy, no, we don't do third-party cooperation, but you must read the whole document. Tammy was engulfed and enwrapped and associated with a whole other group of informants out of Florida, specifically a desperate rat that was in trouble somewhere, and his people contacted her, and they was trying to run a play to get Keith Cromer and DEA Atlanta to do a third-party cooperation with some people out the Southern District of Florida. These informants are terrible. They will do anything. That's why you can't believe an informant. You can never believe an informant because they're going to say whatever they paid to say or whatever they need to say to obtain the goal. Make sure you subscribe to the channel. Salute the real, free the real. Make sure you look it up yourself. Don't believe what somebody tell you. Use your brain.